Hi, it's Dr. Crone, and today we're going to briefly look at the issue of civil rights as taken from your textbook. Just a reminder about the difference between civil liberties and civil rights. We talked about this last week. Civil liberties that you studied last week have to do with freedoms, mostly freedom from government interference in our lives, while civil rights have to deal with equality, especially equality for historic ethnic groups or religious groups or any group in society that has historically been treated unequally. So civil rights is about the struggle for equality. The struggle for equality really began with the 14th Amendment in the United States because prior to that, African Americans were not citizens and they were slaves in the United States for the most part. At least slavery was allowed. And so the 14th Amendment, which was passed after the Civil War, was designed to guarantee equality under the law. Basically, that every citizen had to be treated the same under the law, that's due process of the law, and that everyone had to have the same protection of the law. In theory, that was going to create equality, whereas the 13th Amendment freed the slaves and made these slaves citizens. The 14th Amendment was really the teeth of what was designed to treat former slaves as equal, and it did not work out. Mostly because the courts refused to uphold the 14th Amendment. It was equality on paper, but not in reality. In reality, most southern states during the period after the Civil War went back to something that was very, very similar to slavery. Many black citizens were all but enslaved. Hopefully you're learning about that in your or you have learned about that in American history class. If not, it is good to study those times. We don't have time for this, although I go over a lot of that when we have state and local politics, which is a different class. But there were many laws that essentially in the southern states enslaved African Americans in everything but name. Also, there was institutionalized segregation of education as well as all other public facilities. All of that was allowed by law. So this was not there was nothing about the end of the Civil War that really granted African Americans the equality that probably many both black and white citizens would have expected. The southern states found ways to not live in equality and to have white supremacy and have that be institutionalized by the laws of their states. The Supreme Court upheld this and did not apply the 14th Amendment in the way that it is applied today. And so for 100 years, the Supreme Court said it was okay for southern states to segregate the races. And the kind of keystone court decision that cemented that aspect was Plessy v. Ferguson in 1896, which created the standard, the court standard of separate but equal, which basically said it was okay to segregate as long as the races were provided with quote-unquote equal facilities. And I showed this picture of a Memphis classroom, or one-room schoolhouse essentially, for African American children in 1948 to show that 80 years after the Civil War, or after the passage of the 14th Amendment, this was the situation for many African Americans, where the southern states got away with calling this equal education, which in no way it was. And I'm sure it'd be easy to find a picture of a 1948 white classroom, and it surely did not look like this. So once Plessy v. Ferguson was not overturned until the 1950s, and so until then, these Jim Crow laws of segregation were institutionalized, and it was essentially institutionalized racism. That's a dark period of our history. It's a dark fact of our history. Some of you may have learned to paint a more rosy picture of this in your high school history classes. And part of our job, I believe, as college educators is to undo those mistaken notions and to be very clear and very firm that after the Civil War there was 100 years of horribly legalized racism. Of course, slavery was equally horrible, but not necessarily all gone once the war was over and the 13th Amendment was passed, which freed the slaves. It wasn't until 1954 that the Supreme Court overturned Plessy v. Ferguson, although there had been 50 plus years of efforts by African Americans to try to overturn that law, that precedent of the Supreme Court. There were many, many, many cases before Brown versus Board of Education, but it was not until this case, which you can read more about in your textbook, that the precedent of separate but equal was overturned. And that allowed, once that court decision was passed, the court, in its role of judicial review over the states, forced the states to remedy segregated schools. Even that took a really long time. So between 1806 and 1954, the Brown versus Board of Education, a few highlights of things that were happening that don't get talked about as much in history that were also motivated by the same effort. Shelley v. Kramer in 1948 was a segregated housing case where the Supreme Court said that states were not allowed to enforce what were considered racially restrictive covenants. A restrictive covenant was basically put together by the homeowners association or more likely a property developer that was selling homes that made it illegal for the owner of a home in a certain area, like a subdivision that was being built, for example, to sell it or even or rent it or allow occupancy by a black person or by anybody who wasn't white. And I use this example for those of you that live in Columbus because this is a suburb of Columbus that was built in 1938, Worthington Hills. It's still occupied place, and at the time that was an example of a restricted covenant. There were many, many others in the central Ohio area as well as all over the place. So this was not just in the South. So I'm sorry. So the Shelley v. Kramer decision overturned racially restrictive housing covenants. There was a great case that's very interesting. I wish we had time to dive more into it. I challenge you to look this up and learn more about this brave lady, Ada Sipuel. And her case really forced the Supreme Court to put the money where their mouth was when they said equal in separate but equal. This case was about a law school. Ada Sipuel wanted to attend law school at the University of Oklahoma, and the Supreme Court basically ordered Oklahoma to either admit Ada to the University of Oklahoma or create an African-American law school. And they knew that if they actually created an African-American law school, they would also have to create an African-American medical school, dental school, and lots of other graduate schools. And Oklahoma didn't have the money to do that. So they finally broke down and admitted her to the law school. Her case is fascinating, and she went through a lot of struggle even after she was allowed to attend, struggling with prejudice and discrimination by faculty, fellow students, etc. So I recommend her case. But her case was one where they insisted, finally the Supreme Court insisted that the separate but equal of Plessy v. Ferguson couldn't just be a wink. Like, yeah, we said that was equal. They really forced them to face up to the hypocrisy of that. Although African-American struggle for equality is often what we think of when we think of civil rights, and certainly has been an amazingly important part of our civil rights journey in the United States, there have been lots of other important court cases that dealt with equal rights for other disadvantaged racial groups and even other sorts of disadvantaged groups such as the disabled or LGBTQ people. So I just wanted to take a brief look at some of the other things that were going on sort of during the civil rights era that have provided rights or found constitutional rights for other disadvantaged racial groups. One of the most famous in terms of Hispanic American rights, although this court case applied to all racial and ethnic groups, there was a case called Hernandez v. Texas that was brought by the American Civil Liberties Union. Mr. Hernandez had been found guilty of murder, and the jury was an all-white jury. And the lawyers from the ACLU did some research and discovered that in this particular county in Texas, every jury that had ever been selected in the history of the state court system in that county had been all white, despite the fact that the Mexican American population was quite significant. And so they brought a case on behalf of Mr. Hernandez that made it to the Supreme Court, and the Supreme Court ruled here basically that minorities could not be purposefully excluded from juries. It wasn't a quota in any way. It didn't say that if you were Mexican American, you had to be tried by a group of Mexican Americans. It just said that the pool of potential jurors had to be selected in a racially blind way, so that if there were 20%, let's say, of Hispanic Americans in a county, there had to be at least 20% of Hispanic Americans in the jury pool of potential jurors. Mr. Hernandez was not a particularly innocent victim, or victim isn't the right word, innocent perpetrator. Although his original conviction was overturned, he was retried in Texas with a racially unbiased jury, and they did find him guilty of murder, and he was sentenced to quite a long time in prison because of that. So while he was guilty of the crime, the court ruled that his the due process, he had not been allowed the due process of trial by a jury of his peers. And that is applied to exclusion of all kinds of disadvantaged groups from juries as well, not just Mexican Americans. Another really important case that happened in the 70s had to do with really sort of extending what is meant by equality and equal treatment under the law. And this case had to do with Chinese American students in San Francisco in California. And part of the problem here was that these young citizens who were born in the United States and who were attending school, because they were second-generation immigrants, they were raised in families that spoke only the native language, which is very, very common for immigrants, and by the way, was probably common for your ancestors if they spoke a different language. Generally speaking, first-generation immigrants remain in their native language, such as Polish or Hungarian or Russian or whatever. So this is not, just Asian American immigrants or other immigrants who maintain this language. It's very common. And so that means that their children, while being American, raised in America, probably were raised with a different language as their first language. And the problem was that these kids were having a hard time once they got to school when all the instruction was in English. And so Lau versus Nichols was a court case that said that English language learners had a right, because of the 14th Amendment, they had a right to learn in school in their native language until such time as they developed proficiency in English. So there needed to be kind of a two-track approach to educating them. And this was really the first time the court showed that equality sometimes meant different things for different groups depending on what their needs were. So this was obviously important for English language learners, but it also, the precedent ended up applying later when disabled people were bringing court cases for discrimination against them. And the idea of equality sometimes requiring extra rather than just equal on paper, but requiring extra intervention to provide for equal opportunity, also applied in disability rights as well. So, it's not equal to have a doorway that, for example, a person in a wheelchair can't navigate, or a person with a blind person needs to be provided with Braille in school or things like that, despite the fact that that's extra cost and extra things that are over and beyond what a normally sighted or a normally abled person would need. So Lau versus Nichols is really important. Okay, so up to this point, we've talked about civil rights from the perspective of the court system, and certainly the courts are a major player in deciding, especially the application of the 14th Amendment and how to include various groups in its promises. But court action alone was not the only civil rights activities in the United States. Certainly there were both legislative and executive actions at the national level that resulted in advances for equal rights for minorities. As far as executive action goes, this would be the action of the president and the executive branch to enforce court rulings, and that's a really important part of our checks and balances system, is that the executive is bound by law and by the Constitution to oversee the implementation of court rulings, even if the actual president doesn't like those court rulings. And that was very much the case with Brown versus Board of Education. President Eisenhower was not a particular friend of civil rights. He certainly was not an outspoken advocate of civil rights. He did not necessarily agree with the Brown decision. But once the Brown decision overturned the ability of the southern states to have segregated schools, President Eisenhower was in a position where he needed to enforce that, and his Justice Department, and after a prolonged fight with the state of Arkansas, and that was not the only state that created a fight for the Justice Department, but after a prolonged fight about how Arkansas schools would be integrated, President Eisenhower was boxed into a corner by the governor of Arkansas over integrating Little Rock's school system, and he ended up having to use the force of the U.S. military, so his power as both commander-in-chief and chief executive, in order to enforce that ruling and stop the state of Arkansas from forbidding black kids going to school. So that is a use of executive action, which is an important part of the civil rights movement, is the use of the Justice Department, especially to enforce those rulings. We've seen that in our day today with the Obergefell v. Hodges ruling on gay marriage, and the states that did not want to cooperate with that ruling, and the necessity of the Department of Justice at sort of forcing some states to comply and offer marriage licenses to homosexual couples. So that's executive action. Civil Rights Act, these are the legislative acts, the two Civil Rights Act. The Civil Rights Act of 1964 was mainly focused in its power on the southern states, which had segregated public accommodations, things like hotels, restaurant seating, lobbies and waiting rooms in doctors' offices where, there'd be the colored waiting room and the whites, public restrooms. The Civil Rights Act of 1964 outlawed that kind of discrimination and required all publicly accessible businesses to provide equal accommodations regardless of race or gender, anything like that. And that was passed in 1964. And then the Civil Rights Act of 1968, which was something that was passed right after Martin Luther King was assassinated in honor of his work in this area, was not just aimed at the South. And in fact, the 68 Civil Rights Act had a much bigger impact on the North. It had to do with housing fairness and outlawing things like discrimination in rental opportunities or in mortgage lending for purchasing a home. And so real estate discrimination and landlord discrimination by race, religion, ethnicity, and gender were outlawed in 1968, meaning that a bank had to be colorblind in its offering of housing loans. A landlord had to act in a colorblind manner in allowing or offering rental properties. And this really more affected the North than the South in terms, because the North had a lot of discrimination, especially in terms of real estate purchases, and there was a lot of collusion between banks and real estate companies to outlaw or to effectively make it so that African Americans could not buy homes, particularly in certain areas, and couldn't qualify for mortgage loans. It outlawed those community restrictive covenants that I spoke of before. And this one was really, like I said, this showed the Northern folks who thought that only the South had a problem with racial discrimination that they had work to do as well. There is a misunderstanding of American history that I think is fairly common and somewhat understandable, especially among white Americans, that civil rights is something that was over with and that equality has now been achieved, that the certainly a very common piece of public opinion among white Americans today is that those segregation laws, Jim Crow laws, slavery, restrictions on voting, those kind of things were terrible, and that it's great that we live in a place now where they're over with. And in political science, what we ask is that true? Was the civil rights movement enough? And we have to examine, what do we mean by equality? And what would we mean by looking at it? And certainly this is a more complex issue. So among political scientists and lawyers, there is a distinction made between two types of equality. One is de jure equality. De jure comes from the Latin meaning of the law, and I remember this for test purposes by remembering that jure sounds like jury, and jury reminds me of courts, which is the law. So if you want a quick way to remember the difference between de jure and what we'll later look at as de facto equality. So de jure equality is equality under the law. And this, I think, is what Americans are referring to when they say, like, we've achieved equality. The civil rights movement is done and it achieved its goals. In many ways, there is truth to that statement in the fact that, for the most part, there is equality under the law, meaning that our law is much more colorblind than it used to be, considerably more, both state laws and national laws. Thanks in large part to the Supreme Court, which has forced all civil liberties and the 14th Amendment to be applied in states as well as in the national government. And with thanks to legislative maneuvers and the Justice Department's hard work in enforcing laws. In many ways, there is equality under the law for racial and ethnic minorities, meaning that there are no longer legally allowed laws that allow, for example, a restaurant to force African Americans to sit in a different place than whites, or to specifically say that it's okay for real estate agents to refuse to sell a house in Dublin or Upper Arlington to a black person. That's what de jure equality means. It has been mostly achieved for racial and ethnic minorities, to a somewhat lesser extent, but still to a majority for women. That was later, and there's still probably a ways to go with that. The area where civil rights is active right now, and there has been less progress made so far, is sexual orientation and gender fluidity. Equality is not as far along, but certainly there have been court cases that are moving in that direction of incorporating the 14th Amendment into sexual orientation and gender identity. So in many ways, we can say, if I had to give the United States a grade on de jure equality, I'd probably give it a B+ or an A-. It's pretty far along. But that may not be exactly what we mean when we say equality. And there's another kind of meaning of equality that I would give the United States a very low grade on, maybe a D- or an F. And that is equality of fact, equality of situation, of outcome, of potential. Um, so de facto equality means equality in reality or in fact. Um, if we were going to have, for example, de facto equality, that would mean that we truly had a society where race was not at all related to things like income or educational outcome or treatment by the criminal justice system or things like that. And if you think, oh, that is impossible to have happen, I would let you know that today in America there is de facto equality among white ethnic background. So for example, 100 years ago, if you were an Irish American, a recent immigrant from Ireland or from Poland, if you were Jewish, for example, you, despite the fact that you were white, there was legalized discrimination against you, and there was in fact discrimination in terms of employment, in terms of educational outcome. People who were Irish or Eastern European did not achieve the same levels of financial and educational success as whites from Anglo-Saxon places like England and places like that. So there was racial disparity in de facto equality at that time among white ethnicities, and today there is not. So today, if you are an Irish American or if you are a Polish American, you have just the same amount of possibility of getting a higher education or access to a high-paying job as a person from an Anglo-Saxon background. So that's what we would say de facto equality would look like, would be if they're literally the color of your skin or your what country of origin was only sort of an interesting cultural fact about you. It might affect things like what music you chose to listen to or what holidays you celebrate, but it wouldn't affect things like social inequalities. And we know that's not true today. So this chart shows that over a long period of time, we can see that African American, the disparity between white and black income is significant and has pretty much continued over time. And that is part of what we mean by de facto inequality. Other racial disparities between white people and African Americans are, we know that African Americans have lower education levels, lower college completion rates. That's something that Columbus State is very concerned about and tries to work hard, as do many community colleges, to overcome that disparity. Higher high school dropout rates, higher incarceration rates, higher rates of elementary school grade retention, meaning that if you're held back a year in elementary school for unsuccessful progress, more likely to attend a poorly funded school, public school, and kind of going along with that, more likely to attend a majority minority school. We know that there is a lot of de facto racial segregation in housing. That people who live in a better quote unquote school district, a better funded school district, are more likely to be white and to live somewhere where real estate values are higher. And we don't have a lot of time to go into the reasons why this is, but certainly many people make a very good and strong and well-supported argument that this is not just sort of an unlucky distribution of poor life skills, but that actually the structural problems starting in slavery, continuing with Jim Crow, continuing with things like, if you think about it, up until 1968, it was still okay to outlaw or to not let blacks get mortgages. That's my lifetime. My parents were relatively easily able to, even though they didn't have a lot of money, they were relatively easily able to get a mortgage, where someone my age who's grew up in an African American household with the same income, their parents were very unlikely to be able to get a mortgage to buy a home, and so that's a lot of wealth that ends up going into rental instead of owning property, and a lot of those things were allowed by the federal government. Some of them were actually constructed by the federal government, including great disparities in the way that the GI Bill, which provided housing help and educational help to World War II veterans. There were many, many African American World War II veterans who just did not benefit in the same way from the GI Bill and the GI Bill's assistance with education and home ownership because of discrimination in college acceptance and also in mortgage availability for federally funded loans. So what people who argue that, the government, there are people, quite a few, who make a convincing argument that these racial disparities are at least partly the fault of the American government and its previous allowance of discrimination, and that therefore there is a political reason, an ethical government reason, that to hold the government responsible for creating policies that help to overcome some of this de facto discrimination and de facto inequality. So one of the things that people argue, there's really been two major pushes to overcome de facto inequality. The first was school busing, which came about in the 1970s. And this was due to a court order actually from 1972 that said that because there was de facto segregation, especially in the north of schools, that was just as bad as the legal segregation of schools in the south. And so not only was it required not to have legal segregation, but it also states that had de facto segregation of housing and school attendance needed to do extra stuff, take affirmative action, affirmative meaning take positive steps to address this. And school busing was one of the ways to do it, and I think it was very well intentioned. The idea was that within a school district such as the city of Columbus, you would bus white kids to schools in mostly African American neighborhoods and African American kids to schools in mostly white neighborhoods, so in order to achieve a racial diversity in all of the schools. And this was very well intentioned, and it probably seemed like a good plan. However, it turned out to have a lot of unintended consequences, which was that it basically created white flight to the suburbs. Although that had already started, it gave white homeowners a much more motivation to move to a school district where there was not busing, because there was not a large enough minority population to create busing. What that did was, since you already had de facto inequality in things like income and education level, it took out, it created a hole of wealth. People sold houses in, let's say, Clintonville or places like that that were mostly white neighborhoods within the city. And kind of carved out a big hole in tax revenues and things that could have helped those schools stay, well funded, and eventually it was just a drain of resources, and school busing ended up being so unpopular, and it was unpopular across the racial board because it just turned out a lot of families didn't want their kids, for whatever reason, not necessarily racial, didn't want their kids to be bused to a school outside of their neighborhood because that was a long bus ride and and their friends didn't live near them and things like that. So school busing was not such a good thing. School busing, one way to address de facto inequality. Another way was to allow for and encourage, and in some places require, affirmative action in education and hiring, higher education and hiring. Affirmative action in employment is required by law by any company that wants a government contract. And what it means is that it's not necessarily a quota. What it means is that every company that is hiring, that has a government contract where their workers are going to get paid by government money, needs to study the diversity in their workforce and the diversity in the potential work pool, and work towards having the diversity in the pool of qualified workers be reflected by the diversity in their particular company's hiring. So let's say that you're a government contract hiring electricians. You would have to look at the pool of qualified electricians in let's say Franklin County, and see of everybody who's qualified to be an electrician, what percentage are African American. And then that's the percentage of African Americans you need to be aiming for. Not that you need to absolutely hire, but that you need to be aiming for, and you need to take affirmative action to reach out to folks who would be qualified for the job in those underrepresented categories, women and that's what affirmative action in employment means. That is required by law only for companies that have government contracts, that contract with state, local, or national governments. Not required for privately held companies that don't do business with the government. The other kind of affirmative action is the one we're more familiar with, affirmative action in higher education, meaning preferential admissions for disadvantaged groups in order to create, again, similar to employment, to create a more diverse student body. There are many problems with this, especially from the perspective of white Americans. You know, white Americans, I think, well, all Americans really, but, you know, we have this at least myth in our country of equality and independence and individualism, that people who succeed on their own. All you need is equality of opportunity, and that's enough. And affirmative action programs can feel like they're violating those values, and there's merit to that. There is a perception and/or/slash reality of reverse discrimination. There are interesting psychological mechanisms that go on there. For example, it's shown that if you are used to living in or working in a workplace with 100% white workforce, and your company hires one African American, you often, the white workers see this as reverse discrimination, even though it may not be the reality of reverse discrimination. They see it there because of assumptions that their psychological confirmation bias fills in. The court has acknowledged some problems with preferential college admissions, and acknowledged there is some merit to the fact that we don't want reverse discrimination to be happening, and we don't want these to overshadow the notions of equal treatment. But they have often ruled that workplace diversity and educational diversity is valuable in and of itself, whether or not it's making up for past treatment. And the value, it's okay for schools or workplaces to place a value on that, even if that means it may feel in some way discriminatory to the majority race or gender. There have been a number of court cases that have examined this sort of conundrum, and the courts have recognized the value in both of those perspectives. And over time, they have really sought to to kind of limit and rein in the scope of affirmative action to be sure that while it is meeting the goals of diversity of the institution that has asked for that ability, it is also then not going so far as to tramp on the 14th Amendment rights of white people, and especially white males. And so one of the most important first cases there in this area of sort of reining in affirmative action without stopping it was the University of California v. Bakke, 1978. The University of California Medical School had at the time what were called quotas, where they reserved a certain percentage of seats in their medical school classes for minorities. And Bakke was a white male who was not admitted to this medical school, despite the fact that he had higher qualifications than the minorities members for whom seats had been set aside. And the court agreed with Bakke that this went too far, and that this quota actually did violate Bakke's 14th Amendment rights. And what the court has done since then is make a distinction between quotas, which are illegal, which are unconstitutional, and goals of diversity, which are not unconstitutional. And so in Grutter v. Bollinger, for example, the court reaffirmed and upheld the fact that the goal of affirmative action, the goal of diversity, was a positive one. And basically what they said is that universities are already allowed to use other characteristics for the educational benefits of having a diverse student body. For example, what they said in Grutter v. Bollinger is if the universities are allowed to, say, preferentially admit athletes or academically talented people or artists, many schools that have art schools or drama and film schools or photography schools will admit students based on their strength in that particular area, despite the fact that they may not have the academic record or whatever, similar to athletics. We probably all know about that, living in a place with such excellent college football, that those folks, football players of all races and other athletes of all races, are admitted despite their lack of just academic credentials. And what Grutter v. Bollinger said was, that's okay. There's nothing wrong with that. It's okay for schools to have different reasons for wanting a diverse student body in all kinds of things, whether that's athletic ability or artistic ability, because that is a value of the university. And race or ethnicity could be one of those qualifications, as long as it wasn't the only one to be considered. And that when colleges did that, not only did they need to have other things other than race that they gave sort of special treatment to for the purposes of having a more diverse student body, but also that they needed to show how that benefited students. That it was a clear, for example, educational or social benefit to students to go to school with racial diversity, as well as other kinds of diversity like athletic or academic diversity or things like that. And that was upheld twice. That ruling was upheld twice in Fisher v. University of Texas, which they basically said, yes, we're keeping Grutter v. Bollinger. We're just going to really strictly enforce that second thing, that they need to be able to show a compelling interest and show why this is beneficial to the student body, beneficial enough to put some limits on the 14th Amendment rights of the majority. But it's controversial and it's difficult, and I know many of us, being in the higher education world, wrestle with it. There are other ways, and I want to, Texas has been a standout in this way, as has Georgia and some other schools that had big problems with higher ed diversity. One of the ways Texas has created for this, which has had some limited and kind of controversial success, is they decided to admit the top 10% of any Texas high school, public high school class to their flagship university, regardless of other academic qualities. And this was designed to help overcome de facto segregation by school districts. So we know that people of minority races are more likely to go to less well-funded schools that do not prepare students as well. And this rule was designed to say it's not your fault if you went to a school that had less money or less resources, and if you did the work to be in the top 10% of your graduating class, we will admit you. There has been controversy. That's actually that rule was actually the basis of Fisher v. Texas. Was a white girl who didn't get admitted, who was opposing that rule, and she didn't win her case. So states are looking for ways, and I think the government will continue to look for ways that we can have that meet what is an understandable goal of making up for legal discrimination, de jure discrimination that went on for over centuries, and that lasted longer than probably most people want to admit, and that has generational impacts on de facto potential for equality. So I just want to leave you with that, and thanks for listening. I hope this has been helpful for you in expanding your learning and also understanding the course material. Have a great day.